Mr. Yee, are you aware of any other discussion other than to call it a food manufacturing and processing facility?
I personally, no.
I also noticed that in your determination letter, you also don't ever expand on that. Am I correct? Again, it's just labeled or identified as a food manufacturing and processing operation. Correct?
Correct, as a permitted use, yes.
So when you issued the developer a minor permit, you did not know what kind of food processing or manufacturing facility was going to be taking place in the warehouse. Is that correct?
We knew the general use, which was permitted uses. Whether or not we knew the specific tenant, that wasn't selected at the time.
Do you agree that it would be important to know the nature of a proposed food processing operation in order to determine whether there would be an environmental significant consequence or not?
So as they proceed with their plan approval and through the process, there would be chances for further review. Also, there are conditions in the permit.
Isn't the SMA permit to be treated separately and distinctly from the other permits?
I think that's what Mr. Strauss has been arguing.
The SMA permit is allowing them within their uses that they have. Specifically, if the use brought up a question at plan approval, adjustments could have to be made to that specific use based on health regulation, water use, or something. So adjustments could be made within those uses.
Without knowing what kind of a food processing plant was designed or proposed, could you make that decision?
Objection lacks foundation as to when, talking about plan approval.
For approval of the SMA permit.
And I'm going to sustain the objection for different reasons, but the question answers itself. Can you make a decision without knowing something? You can't make a decision about something without knowing something, but I don't think the witness said he did, or that anybody did. You're saying, how
Did
can
you know what
decide?
kind, I'll go through the whole thing. Did you know what kind of a food processing plant was going to go in there?
In detail, no, but at this point in time in the process, you don't have to know the exact.
So it is your testimony that you do not need to know what kind of a food processing plant or facility is going to go into the warehouse before you issue a minor permit, because you've decided that the minor permit, because you've decided the project will not have an environmental effect on the area.
What was determined was the use was appropriate. That's what the minor permit acknowledges.
Okay, so is it your testimony that if the use is appropriate, meaning zoning, am I correct?
Correct.
That's what you're talking about. If the zoning use is appropriate, then the minor permit becomes appropriate.
It's not the only criteria.
What are the other criteria?
Objection, the permit speaks.
Correct.
There are a dozen of them listed, Mr. Kay. I think as far as your line of questioning goes, he's agreeing with you that at this stage, they take the general zoning and they decide if that's consistent, and if so, that may allow them to grant the SMA.
Okay.
And if I can interject, I hope it'll speed things up. Are you saying, Mr. Yee, that if at some point in the future you became aware of facts that contradicted these things, you could revoke the SMA?
Absolutely.
Thank you.
What is contradicted Mr. Chair? Contradicting
Nothing,
what
is
facts?
nothing yet, we don't know yet.
But I'm saying if the plant was consistent with zoning, what's the contradiction?
Something that would be inconsistent with zoning. But you're talking about the difference between specific permitted uses within zoning. So, as I understand it, something can be zoned industrial, but you can't put in a soap tallow factory that'll have noxious smells necessarily, just because the zoning allows industrial. And if they found out that, in fact, what you had in mind was a soap tallow manufacturing plant, they would revoke at that point, or they would attack the permit in some collateral way and say, you can't do it. But at this stage, we're dealing with the question of, is this consistent with the zoning such that they can say, okay, this is, from what you've presented to us, it looks like an SMA minor. But they can change that later on if the facts change.
Correct. I do know in review of applications, for instance, for Department of Health issues, and just using this as an example, if the Department of Health raised questions about a specific use that may have been a permitted use, general activity, but they have a specific question about a certain activity such as being a fertilizer plant or a storage area, they could raise questions and then we would then review and maybe determine the use was inappropriate. And then we would revoke. I would also say if the permit, like as I said earlier, there are conditions, there are representations that the applicant makes. At any point we feel like they are not consistent with the conditions, with the representations, we can rescind the permit.
If it's consistent with the zoning, can it be revoked?
Yes, because it doesn't comply with permits, federal, state, county agencies, applicable laws or regulations. It could be revoked. It says it right there on item 2.
I'm not going to debate with you, but I don't
Well,
think
that's not subject. Look, Mr. Kate, it seems to be you're trying to get.
I'm trying to say, I'll say it.
Yeah.
I think the SMA is extremely important in the sense that a decision being made at this point, if it's consistent with the zoning, can be very hard to undo if you've already said, I have no problem with the special management area for this project.
But as far as the zoning goes, you may be right. There might be a lot of reluctance to undo it, but is that the issue? The issue that you seem to be assessing is that the specific activities that may be undertaken here should render this project not acceptable from an environmental and at this stage of your questioning or ecological standpoint. I understand from what Mr. Yee is saying, that's a separate question as to whether they're entitled to an SMA minor or not, that those questions will be addressed separately. I don't see that you're going to get them to say anything different from that, no matter how complicated you make a question. That's what he said. This is as far as they go on the SMA minor. It can be undone later if, as things materialize, they don't comply with permits and specific uses and procedures and statutes and regulations. But right now, this is a general granting of an SMA minor. If they see bills coming in for $2 million worth of development, they're going to say it's revoked.
Yep.
I saw that as a condition. I saw that as a
Okay.
condition.
And they're going to say
I did not see as a condition that if your approval that I'm giving you for your SMA turns out to be obnoxious, noxious, just within the legal limits of zoning, but it's noxious, then yeah, we take it away. I just don't see.
Your implication is that there are no regulations, rules, or statutes that govern those activities, and I think that people would disagree with you as to that.
In a special management area. Okay.
Mr. Chair, since we're having a dialogue, I'd like to direct the Board of Appeals to condition approval number 4. This is where the answer lies to these convoluted questions. The applicant shall secure plan approval. He still has to go through another process That's when these issues come up.
And I was alluding to 2, which basically is preliminary to that, says the same thing. And going through that process, he has to comply with rules,
Can we
regulations.
finish the questioning of the witness and
Yeah.
get on?
Yeah,
I think
Because
so.
you guys are making statements already. I like to
And I
finish the.
apologize for that, Jay.
Yeah, I want to finish the questioning and then cross-examination
Right.
and get on with it. We stayed here till 5 o'clock
Yeah,
last time.
that's right.
And this is a continuance, so let's get on with it.
And
Okay,
and
would
Mr.
you turn
K,
to page 978?